Welcome to Empowering Workers, Federal Employees' Disability and Employment Rights and Social Security Disability for All.
Hello and welcome to Empowering Workers, Federal Employees' Disability and Employment Rights and Social Security Disability for All with Eric L. Pines. Eric is a nationally recognized federal employment lawyer, mediator, and attorney business coach. He represents federal employees and acts as in-house counsel for over 50,000 federal employees through his work as a federal employee labor union representative. I am your host, Kevin Rosenquist, and today's episode is Ensuring Equal Access, Advocating for Federal Employees' Accommodation Rights. Eric, so great to see you.
Oh, it's such a pleasure. Pleasure to see you again as well.
So you've built a successful career advocating for federal employees' rights with a special focus on disability and employment's rights and also representing others in Social Security disability claims. Can you share a little bit about your practice and what inspired you to focus on these particular areas of the law?
Sure. So I was a federal employee myself a good 30 years ago. I used to work for the U.S. courts. So I got an insight into being a federal employee. I enjoyed it very much. Then when I moved on to start my practice, I found this niche of federal employee law, started as an in-house counsel to a labor union, the largest labor union in the United States. And as I learned more and more about the field, I recognized that it's one of the few areas of law that are very pro-employee rights. So I started to work exclusively in that field. That's all I did for a while. And then I ended up leaving the union to start my own practice about 15, 20 years ago. That's what I did. But while I was doing it, I found that I gravitated to particular areas that I truly had a passion for. Because like everything in life, if you love it, if your heart's in it, you do a better job. So what I found was that disability rights, as far as helping employees with accommodations, has two amazing qualities that attracted me to it. Number one is really helping people who need your assistance and who are a little bit of an underdog, that's sort of fighting for the people who can't fight for themselves.
David Goliath.
Yes, exactly. That's number one. And number two, there's nothing better than fighting for someone where the rights are actually on their side. And while it's very difficult to win some discrimination cases in general in the EOC, reasonable accommodation cases are very, very pro-employee. And as we'll probably talk about more during this discussion and in the future, the disability rights are on the employee side.
What about your practice so far has been the most rewarding?
I would say it's basically being able to help people who are at a difficult time in their life, who feel like the world is not on their side. They've got a supervisor many times and supervisor who are just trying to get the work done. Look, we're all human. We know that there's a job to get done. They call it an FTE. There's full-time equivalents. People are encumbering a position. They're in a position, and we all pay our taxes. We want employees to work and we want them to get the work done. But there are and so sometimes in the shuffle of that, you've got a supervisor or an agency who's really pushing an employee to get the job done and doesn't have that sensitivity with just a simple accommodation, with just a simple working together. They call it the interactive process. You could really get that employee to be more productive. You could really get that employee to benefit. I mean, the agency has already devoted years usually into training that employee. That employees usually has done well until their accommodation needs jumped in. So to be able to get in there, help that person, even help the agency to work together as a team to get that employee accommodated and get them what they need so that they can really excel in their life and they don't have to go to retirement, which we'll talk about later. That's something that's very satisfying. And then I would even take it a step further. I would say sometimes that employee doesn't recognize that there is no accommodation that they truly could acquire to allow them to continue to do the essential functions of the job, is the legal term. And in that case, then the beauty is to be there for the employee and to tell them that the federal government has set up a double system to protect them. There's Social Security disability, which is an area we assist with, and then there's disability retirement for civilian federal employees. So to be there for that federal employee to say, hey, let's get you that accommodation. But if we can't get you that accommodation, believe it or not, this may actually pay you more money. Many times it does pay you more money than what you made when you work, and you still get your retirement benefits. So it's a beautiful thing to be able to be that right-hand person to somebody who needs you.
Yeah, that's awesome. I really like that. Well, let's get into the meat of what we're talking about today. Let's start with navigating workplace accommodation for federal employees specifically. I can imagine the process can often feel overwhelming. So what are the first steps someone should take when considering an accommodation request, and how can they ensure they're on the right track from the start?
Well, I think the first thing is to look inside yourself as the employee, to say to yourself, what accommodation works for me in my home? What accommodation works for me in my acts of daily living when I'm out in the world? Whether it's, let's say person has ADD and very severe ADD, and they recognize that having things put into notes or something for them works for them. Okay, so then you start questioning, okay, is that something that we can ask for at a meeting? Can I have things transcribed for me? Or let's say somebody has a more serious, not that that's not a serious disability,
Sure.
but something, let's say like cancer or something very serious. So to brainstorm by yourself, step one, what could really assist you do the essential functions of your job. Then turn to maybe your medical provider and ask them what they've seen in the past, to ask their recommendation, what they think would help, whether that's a therapist, psychiatrist, doctor, medical doctor, what kind of accommodations have they seen worked? And then finally, maybe turn to the web, or maybe even start here at the web. There's tons of resources online. There's JAN, which is Job Accommodation Network. .gov, I think, or .org. There's other websites you could turn to. Federal government has its own websites. I think JAN is actually a federal government website. There's my website, pinesfederal.com. We have a whole section, blog on reasonable accommodations. So that's kind of a three-prong approach. Just to recap, there's looking inside yourself, what works in your life. Number two, seeking out that information from a medical provider. And then there's looking at outside objective analysis from websites. And finally, throw in the final one is sometimes your supervisor will know what's good for you. And to work with your supervisor as a team, obviously, when both people are bought in, you're going to have a much more successful outcome.
Absolutely. And how does a federal employee know if they're eligible for workplace accommodations under the law in the first place?
Great question. So you have to be a qualified employee. That's number one. And number two, you have to be able to do the essential functions of your job with or without an accommodation. So those are terms of art. Those are legal terms. Let me make them simple. Let me put them in practical English. So what does it mean to be a qualified employee? Really, what it means to be a qualified employee is that you can do your job, like I said before, with or without an accommodation. So it could be, well, I should really jump back for a second. You first have to be disabled. Now, the reason I didn't go into that first, even though that probably is the first analysis you should go into, is the law changed a while back. It used to be much harder to prove you were disabled. I think George Bush put the ADA in effect many, many years ago, and there were some gray areas as to whether people were disabled. But then I think about 10 years ago now, the Americans with Disabilities Accommodation Amendment came out, and it made it much more easier. It's very easy to show you're disabled. If you have a disability, you don't have to prove you're disabled for at least a year or even 6 months sometimes. So generally, but obviously you do have to have a disability.
Right.
So let's assume you have that disability.
Yeah, we can assume that for the sake of the conversation. Yeah.
Exactly. So then you move into whether you're qualified, which really is just a simple question of obviously, without the accommodation, since you need the accommodation, you might not be qualified, but with the accommodation, which practically means, for example, let's go back to that person before, the ADHD person. They have ADHD, they have focus abilities, so they're not getting their job done and their performance is suffering. Sooner or later, he's going to move to remove them with a performance action or a disciplinary action to get them out. However, with the note taker, if that allows them to perform adequately and get their job done, then boom, they're qualified. And if they're qualified, then that answers your question. Then they can apply for a reasonable accommodation.
What kind of documentation is needed or proof or in order to show that they're disabled?
It's a great question. And the answer to that relies on what's your disability. A blind person doesn't have to provide any document. If it's open and obvious, if you've got yourself, a walking stick, or your supervisor knows you're blind, or if you're deaf, or if you have a horrible limp or you're in a wheelchair, open and obvious, you don't need any documentation. The law really protects you. It says if it's open and obvious, no documentation necessary. But most disabilities are gray areas in general. People have back issues. There's people who, like I said, have ADHD. There are people who have other disabilities that relate to emotional things that need to be diagnosed. So in that case, then you're going to have to, generally you can first start by making the request without the medical, but the agency will have a right to go back to you and request some information to prove that you're disabled from a medical provider. It is a gray area. If if it's open and obvious, then no, the agency will probably request it, but you can just ignore them and you'll have the law on your side. That being said, in general, I tell my clients, why not get the information? Because you can be right, but you could be right and have to pay an attorney a lot of money to prove you're right. Why do that? Why even have to pay the attorney if you come up with the medical documentation in advance to make things simple?
That's a good point. Yeah. If an employee wants to initiate an accommodation request, how do they do that with their supervisor or their HR department, however that works?
Again, the law is on the employee side. You're going to find that as a theme that'll run through this. They could ask their supervisor. They could ask each agency. Many agencies have reasonable accommodation coordinators. I know the VA has the LRAC, they call them. Or they can go to the EO office. They could go to anyone in their supervisory chain to ask that question.
Mm-hmm.
They're really free to ask anybody in management or in the EEO office. That being said, if their accommodation is, again, open and obvious, they don't even have to ask. If a blind person comes in, they hire the person, it's assumed that they might need or I should use a deaf person for this example. If a deaf person comes in and they can't hear, it should be assumed that they probably need a sign language interpreter on occasion, or they might need a teleprompter of some sort, TDD or whatever, TDY, whatever it is. So make a long story short, it depends on the situation.
Yeah. It sounds like, there's so many different ways you can be disabled. As you pointed out earlier, it definitely makes it a little more difficult to answer a question like that. I totally understand. So what types of accommodations are the most common as far as being requested by federal employees?
I'd say the two most common, number one would be work from home. And that has become an interesting area.
It certainly has, hasn't it? There's some strong opinions on both sides.
For sure. There was a while where basically the government was working towards getting as many people to be able to work at home as possible.
Oh.
Then when the first Trump administration came in, they really tried to cut back on that because there was a fear that people weren't working from home.
Mm.
And in some cases they were correct. Obviously, in some cases they're not correct. Every person's an individual. But that filtered over into the disability. We had a lot of cases during the first Trump administration where people were told to work from home, and the agency, the government, had just made an assumption that, hey, we pulled your rights back, and they forgot that this person actually they're not working from home because they want to work from home. They need it for a medical accommodation. That made for a lot of interesting cases where a person said, okay, you might be right that you're taking away our right to work from home, but the law is actually on our side I should say I'm actually requesting it as a disability accommodation. And that changes the whole story. And like I said, the law is on their side. Then after Trump left, things swung back a little bit with the Biden administration. And then, of course, they had that overlap between the two, the COVID-19. COVID-19 opened a whole can of worms of, well, all these people you said they couldn't work from home. Well, now we proved that they could work from home because everybody worked from home.
Yep.
So it's really been a back and forth, but I think we all know work from home has become a lot more prevalent than it used to be. So answering your question, work from home is one of the biggest ones. Now, I always tell my clients, if you want to work from home 5 days a week, every single day you're working, that's going to be a different request than 2 to 3 days a week, because many jobs require you to come into the office at least to meet with people once a week. I
Sure.
often say, don't start with that, because you may put yourself in a position where you're going to get fired because you're not doing the essential functions of your job. So that's one. Number two, I would say, is probably after work from home, it would probably be people requesting medical devices, depending on what their actual need is, requesting medical leave.
Oh, sure.
So a person may have run out of leave. So a lot of people don't realize that they can actually request more leave, put themselves on leave without pay, and not be marked AWOL, they call it, because they're asking for it for medical reasons. So that's something as well.
How should employees approach their employer if they fear retaliation for requesting an accommodation?
That is $100,000 questions, probably moved up to $1 million.
That's probably a lot more these days, but I know what you're talking about. I love the game show.
I think it depends on the humans involved. If your supervisor has a empathetic, sensitive side, approach them with a way where, hey, here's something that could help both of us. Mm-hmm. Why don't we work together to see what could work? And the law requires something called the interactive process, where you go back and forth. It doesn't matter what the law requires. We're talking practical here. We want to be real. You're sitting there in front of your supervisor. You're not going to say, well, the law requires, at least most people don't say that. They don't want to get bad performance appraisals. So they want to present it, like you said, in a way that's not going to be confrontational. So you start off by saying, could we work together on this? That's one way. If you get to the point where accommodation is necessary and the supervisor or the EEO office, the reasonable accommodation coordinator, is not heeding your requests and not taking you seriously, then you might start saying, pulling out the law, You might want to go to my blog or look it up online. And if you really need the accommodation and they're not assisting you, you might want to call an attorney. And we do reviews in our firm, extensive reviews where we give people advice. Many times we charge for our case review because many times we don't want the person to pay for us to do an actual case for them, because that could get really expensive. Instead, we'll educate them on what they can do for themselves during that case review. And we'll tell them the best way to approach their supervisor.
How can employees advocate for themselves if their initial request for accommodation is denied?
So if the initial request is denied, you can reapply. The truth is you can reapply for accommodation as many times as you want. There is no limit. Obviously, it's going to get boring and old after a while, and you're going to annoy people. But just be aware, you can certainly apply again, and this time bring a doctor's letter, or this time come with some new information. That's one way to do it, the non-confrontational way to do it. The confrontational way to do it is basically you could file a discrimination case in the EEOC. Every federal agency has its own EEO department, and you can file what's called an informal complaint. Obviously, before you go there, I shouldn't have jumped that far. Many times there's that reasonable accommodation coordinator. Work with them for a while, see if they'll assist you. If it's clear that they want to assist you, then you're going to want to maybe reach out to an attorney to get that review what I was talking about, or just go ahead and file it, see how it goes, and see if you need an attorney after that.
And how important is early legal intervention?
Extremely important. Legal intervention to get that advice is probably the best way to say it. Not to sue. Ironically, being a lawyer, I'm not a litigious person, even though I look at my docket of cases. I guess I would argue, but personally, I'm not a litigious person. I believe that people are going to get a much better outcome in life by, like they say, you get more bees with honey. Yep. You treat people with respect. You keep the relationship alive because you have to work with that person before and after you get the accommodation.
Yeah. How uncomfortable would that be down the road?
100%.
And finally, what is the role of your firm in ensuring federal employees get the accommodations that they need?
So our firm, since this is our passion, and not just me, everybody in the firm, is a great firm to go to. Obviously, we're biased, but it's a focus that we really know the intricacies, the ins and outs. So the so the law that protects you as a federal employee is the Rehabilitation Act of 1973. That act incorporates the entire ADA, the Americans with Disability Act. So it's basically the same law. So you want to speak with somebody who really knows the ins and outs of ADA law through the Rehabilitation Act and understands more than just the law, but how the process works, because it's extremely unique to the federal sector. I can't tell you how many times I'm telling people or I'm speaking to people about the fact that many times you'll hire the local attorney or a local employment attorney who doesn't know federal employee law, and you're basically paying to get that person up to speed, which is not fair to you to have to pay them to learn federal employee law because it's so unique. The attorney might mean well. They might not even know that federal employee law is administrative. It has its own rules and regulations. But in the end, if you don't go to an expert who really understands federal employee law, you're going to be spending resources on just getting that attorney up to speed. So getting back to our firm, this is what we do day in, day out. This is, our passion. We understand the law. We've won many a case before the EOC, the Merit Citizens Protection Board. So we are, what I would say, extremely, extremely well versed in this field. And so you're going to basically jump the curve and save money, save time, save energy to come to a firm that really understands the process.
It's always good to have an expert on your side, for sure.
Yeah, 100%.
All right. Well, thank you for tuning into Empowering Workers, Federal Employees, Disability and Employment Rights, and Social Security Disability for All with Eric L. Pines. To connect with Eric, head to pinesfederal.com. And of course, be sure to like, subscribe, and give us a review in the comments to the channel. We love having you be a part of our community. Eric, so good to see you. Looking forward to talking with you more.
It's great to see you as well. I really appreciate your time. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.